on this morning's Ag Issues program. As always, a pleasure to bring on to the program Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thank you.
All right, we got a couple of main topics that we're going to discuss today, and we're going to start actually in the Kansas legislature with a couple of bills that are currently on the books. But this is a much bigger current topic that we're going to discuss on that. And of course, it is the foreign ownership of agricultural land. And of course, that has been heightened or highlighted more due in part of the current situation of other issues across the world, specifically concerning China and Russia as well. But there's a lot of things that you hear, but then a lot of things you don't hear about, foreign ownership restrictions and actually acts of Congress that we have on the books already in this case.
Yeah, that's right, Greg. Indeed, the 117th Congress enacted certain changes. They introduced a range of proposals to address concerns involving foreign purchases of U.S. ag lands and investment in U.S. food and agricultural sector. Some of those proposals would have restricted USDA program eligibility to foreign entities. And now the current Congress is kind of considering those types of proposals involving USDA. And it may even come up, Greg, I would suspect, in the Farm Bill debate, whether they may put some additional restrictions on foreign ownership or foreign interests in agricultural land in the Farm Bill. There are some other congressional proposals that reflect various national security concerns, and of course that's what the whole issue is with respect to foreign ownership. It's a national security, a food security issue, and it always has been, even dating back to English common law several hundred years ago, and at the time this country was formed, we've always had this issue that's out there. And so I think you're going to see the current Congress continue to deal with whether it's the issue, whether it's inside or outside of the Farm Bill context.
Explain a little bit, too. This would have been, I think, in 78. Congress back then, that being under the Carter administration, enacted the Agricultural Foreign Investment Disclosure Act. How does this tie into what is being discussed right now?
Well, that was a nationwide system for collecting information that pertained to foreign ownership of U.S. agricultural land, and that's defined as land used for forestry production or farming or ranching or timber production. And the specific definition, and when we talk about this subject, we have to be very careful of making sure we define the terms appropriately, because this stuff can be misconstrued. It can be demagogued by politicians pretty easily. But when you look at the definition under the federal law of what a foreign person is, it's any individual or corporation or company or association or partnership or society or joint stock company or trust or estate or any other legal entity or any foreign government, but any entity that under the laws of a foreign government or has its principal place of business outside the United States. So it's very broad. And so if you are a foreign person, as that term is thus described, then you have to reveal your information. You have to report your information if you buy, sell, or gain any interest in U.S. ag land, to report your holdings and your transactions to the USDA directly or to the Farm Service Agency county office where the land is located. And if you don't do that on the disclosure form, which is FSA 153, then there can be some penalties that can and fines that can apply.
So as we look towards, and Kansas is one of many states that are looking at these restrictions, and how are these being designed, or I guess, how are these being proposed as far as restrictions are concerned?
Well, Kansas is one of a number of states that currently has a restriction. If you just kind of think of a map of the United States right now, where are the restrictions at? They're basically in the center part of the country. So if you start in North Dakota and you go south down through Oklahoma, and then go over to Minnesota and come down through Missouri, go grab Wisconsin and Indiana, Kentucky, Mississippi, Pennsylvania, South Carolina, those are where your restrictions are at. Now, other states either expressly allow it or are silent. A big one that expressly allows it is Texas. Of course, you had a major land purchase by a Chinese outfit down in Texas, and that's raised some concerns for them. They have a bill that's on the table. But a lot of states that either have restrictions or tightening up those restrictions, or other states that don't have restrictions, such as Texas, have bills in their legislative sessions this session. Now, Kansas has two. Kansas has one in the House. It's House Bill 2397. Kansas has one in the Senate. It's Senate Bill 100. And the Kansas restriction, the current restriction, comes through basically the anti-corporate farming law. Now, the Section 17 of the Kansas Bill of Rights says that the rights of aliens, that's the term that's used, in reference to the purchase, enjoyment, or descent of property, may be regulated by law. So it's in the Constitution in Kansas that that right of an alien to buy or enjoy or inherit property can be regulated. And so that gives the legislature the power to do that. Then you go to the anti-corporate farming bill, which, by the way, Kansas had the very first anti-corporate farming provision of any state in the country. There's a reporting requirement. And so every foreign corporation that does business in Kansas has to make a written business entity information report to the Secretary of State. There's some other things that are in there, but it's basically a reporting requirement so the state can track who owns or has interests, who is foreign, meets the definition of a foreign corporation or a foreign entity or foreign person, so the state can track ownership or holdings in agricultural land in Kansas.
So, in other words, say, with the push on renewable fuels that we have seen here for the past many years, that may have a foreign interest as far as an ownership is concerned. So would that be affected in any way?
Well, that's subject to the reporting rule right now. That's how we know in Kansas that foreign ownership in terms of foreign holdings is just a little bit under 2% of all privately held agricultural land in the state of Kansas. And I've got maps that can show you where those are at. And you'll notice when you look at those maps, the acreages are higher in a county where there are wind farms, because those are either often they're Italian or countries in the Netherlands or Germany or something like that. And so that's popping up on the map too. Those are holdings. Now, a lot of you talk to farmers that have entered into lease agreements with wind energy companies, these foreign-held companies. They'll tell you that the leases are so long and the contracts are, in their words, in many instances, so egregious that it really amounts to ownership to them. But technically, those are holdings. But those get reported too. Now, what the current proposals in the Kansas legislature do, they take different approaches. The House bill takes a different approach than does the Senate bill. And the bill in the House doesn't limit the restriction on foreign ownership to agricultural land. It doesn't do that, but it doesn't prevent residential home ownership by a person who has dual residency in the U.S. and a foreign adversary. And that's the terminology that the House bill uses. It doesn't put a restriction in unless the association is with a foreign adversary that is on a list that is defined by the federal government. And there are 6 entities or 6 countries that are on that list right now. And, of course, China is on there, Cuba, Iran, Korea, Russia, and Venezuela. And so if you have an interest, if you are controlled by or you're a foreign agent of those countries as an individual, then the House bill would restrict foreign ownership would restrict you from owning Kansas land. If you have dual citizenship with those countries, it doesn't. If you're an individual that's not controlled by or subject to the jurisdiction of those countries in a way that they are that you're working for them, basically is what the House bill says, then the restriction doesn't apply to you. So you could have say somebody that comes to a university in Kansas to work that's from one of those countries on that 6th list, and as long as they're not, in essence, a foreign agent, there's no restriction on them owning a home in the state of Kansas. And I think that's probably a pretty reasonable approach for the legislature to take in this one. And of course, there's the concern and you probably reported it when it came out a few years ago, of the Chinese national, Greg, that got caught in an Iowa farm field who was stealing trade secrets, and DuPont found him. And so that's the concern that's out there, of what type of our ag technology is being misappropriated, is being stolen, and going to countries that hate us and want to do us harm. And so that's what the legislature is trying to address. And the House bill is pretty narrowly tailored and says, well, if you're associated with a country in a way such that they're controlling you, and that country is a foreign adversary, and that's a really small list, then this new legislation, the House bill, would create an additional hurdle for you as an individual to own a residence, and ag land would be a no-no.
So, in essence, the difference between, in this case, a national security issue and control of the food supply, really, you can't say those are, some would construe it as political issues, but they're really not political issues. They're national issues.
No. Yeah, this has never been a political issue as far as I've seen it. Even, if we start back with common law in England and then from the foundation of the United States, it's always been a concern about who controls the food supply. And that was the concern of the King of England way back centuries ago. They didn't want someone that was disloyal owning the land and hence owning the means of production of food. And that's a very reasonable position. And many countries have this view too. And so that's a thought process that carried over into the United States at formation. And I've never viewed this as a political issue. It's just simply not. It's a national security and food security issue.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is our guest. And Roger, let's go to another part of this discussion we're going to have this morning. And, most operations, ag operations, I should put, depended on borrowed money or financing to continue their business. And you had a recent case in Texas. This is concerning a bank in Texas that got confused on the financing rules governing agricultural crops, and ended up losing their security interest as a result as well.
Yeah, these ag financing rules can be pretty confusing, but the facts on this are actually pretty straightforward. You had a farm couple that borrowed money from their lender, which is AgriFund, and that's a major lender for farmers across the United States, and particularly in the center part of the country. And they got multiple extensions of their credit lines with the final promissory note that they executed in December of 2017. And so AgriFund perfects a security interest in their crops, among other items, and they default on that loan in the spring of 2018. And then since they're in default with AgriFund, they go to a local small-town bank a little bit northwest of Lubbock, Texas. So this is way out west and up north, basically straight south of Elkhart, Kansas is where this is at. And they go to the bank, and the bank loans them money, and they use the money to buy cotton seed and chemicals to allow them to put in their 2018 cotton crop. And they granted the bank a security interest in all crops grown or to be grown for that 2018 crop. Well, remember, AgriFund is sitting out there and has already perfected a security interest in their crops. They defaulted on that loan. Then that fall of 18, you have the cotton harvest, and the couple sells the cotton crop, and the local elevator is wondering, well, who do I pay? And so they write checks both ways, and AgriFund said, no, that all belongs to us. They're in default. We filed first. And the bank trotted out a rule that said, well, we have what's known as a special rule here that we can use. We get a purchase money security interest in that cotton crop, and we jump ahead of you as the prior perfected lender, AgriFund. And they were basically relying on a rule which had been removed from Texas law about 20 years earlier, known as the purchase money security interest in crops rule. And they tried to say, well, we took an interest. The purchase money collateral was goods, and the goods at issue were the seed that the farmers bought, and seed is the same thing as crops. And they pointed to a Texas code definition that says goods are all things that are movable. when a security interest attaches and includes crops grown, growing, or to be grown. So this kind of stuff can get really confusing. I know it's hard for people to track what I'm saying here, but basically the bank, and I don't know whether they just simply didn't know the rule or didn't check the public filing record to see that AgriFund already was a prior perfected lender, and then they're coming up with an argument after the fact. I don't know the background behind this as to why the bank did what it did, but this is an interesting argument, and it's flawed in many respects because it raises the question of when does a seed become a growing crop? Well, you don't. A seed is not a growing crop at least until it's planted, probably not until it germinates. And so, by saying that you have the interest, you have a security interest at the time of attachment, and you've got to have a good at that point in time. When they borrowed the money, there was no seed in the ground that could have possibly germinated at that time. And so, it was pretty easy for the court to say, "No, you're completely unsecured, bank. You misread the law. There is no longer a purchase money security interest in crop rule. That was removed in 1999, and you lose your interest to AgriFund." And that, frankly, is the right result, simply because we don't have that PMSI and crop rule anymore.
And have we seen similar cases like this in other states that have taken place?
You know, I haven't seen one this egregiously bad that just simply, I guess, forgot that there was no PMSI and crop rule anymore. Now, there are a few states that have gone back in by statute since that rule was removed out of what we call the Uniform Commercial Code, and they created their own separate statutory provision. Iowa is one of those. They have what's called an Appendix 2 provision. Texas never did that. And so the lesson, I think the take-home out of this, if you're a lender to farmers, is be very careful on these types of things. Make sure you always check the record. Maybe AgriFund misfiled. Well, that would be an argument that you would have, but there's no allegation of that in this instance. Misfiled by using the wrong name or putting a period in the wrong place or abbreviating the debtor's name so that you couldn't find it when you check the public filing record. But lenders have to be very careful on these things and make sure you're aware of what your state has actually done. And at some point in time, I'll find out the backstory on this. I just don't know that yet as to why the bank loaned the money in the first place. What they should have done is to tell the farmers, you could go to an input vendor and just buy the seed directly from them and have them finance it, because Texas has an input supply dealer lien. And that would have given the supply dealer a lien on the seed to put the crop in the ground, and they would have been on equal priority with AgriFund in this instance with respect to that 2018 cotton crop, not with respect to everything else that they might have financed, but with respect to the 2018 crop. So there is a little bit of a way around this, but wow, for the bank to do this and they lost their whole interest, that's a tough one.
Bottom line in all this, one would think, is simply understanding the ag financing rules, and I guess somewhat this goes both ways, both from the farmer side and the financier side.
Exactly. Yes, that's a good point. And this was great in one respect for me, because I had just covered this subject with my law students at Washburn, and here comes this case, and it really puts a face to what I'm trying to tell them, what I'm trying to teach them. They could see it in its application. And so that was great for me, but to drive a point home. But you're right, farmers and lenders and rural lenders in particular, a lot of these ag rules are really different, and they're unique, and we just have to be aware of that. That's one of the things that makes agricultural law very unique in and of itself. It's kind of law by the exception in many instances.
Yeah, absolutely. All right. Roger, if people want to see more or read more about this, both of these topics are on your probably your recent blog post.
They are, and people can find that at washburnlaw.edu/Walter. They're also on the K-State Econ Ag Manager website.
All right, sounds good. Well, Roger, as always, I very much appreciate it. Thank you very much.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law as he joins us on the Ag Issues program here on 580 WIBW.